come back at that point. Again, we have a lot of coffee, so please drink up. There's water and pop in the Yeti, which is my parents. So
You're welcome. You're welcome.
Yeah, and then there's some pop and water again in the fridge down there too. So thank you. You did great. Yeah. No, well, you only have 10 minutes, so you did great. Going to talk to us about all of these are really important topics, but in my opinion, this is a very important topic. Crucial conversations 101, how to talk to co-counsel, opposing counsel, clients, or coworkers, and how to do that well, especially when the stakes are high. So thanks, Eric.
Thanks, Brooke. Thanks for having me. My name is Eric Schulte. I practice law at the Davenport Evans Law Firm. I know many of you in here, not all of you. I've been doing this, I can't believe it. I graduated in '99, clerked for a year, and I've been practicing since August of 2000, so coming up on 22 years. Primarily in litigation. Raleigh asked before if you want to be a prosecutor or a criminal defense lawyer. You should do criminal work if you get a chance. And I interned in the prosecutor's office, one of the best things I ever did in my life. But my career path has been primarily civil litigation. I do a lot of personal injury defense. I do commercial litigation. I do some criminal work as well, just enough to be dangerous. I've got Clint Sargent and Raleigh Hansman on speed dial when I've got questions. They help me out. But it's primarily civil litigation. The topic Brooke asked me to talk about is very broad. It covers a lot of ground. Communication with your opposing counsel, with your clients, or with your coworkers. And I've got just a few things that I want to discuss with you that I picked up over the last 22 years. So hopefully be helpful. Please ask questions as we go along. If anything comes up, I'll talk for maybe 30 minutes and we'll have time for questions at the end. But if anything comes up, please raise your hand. You could summarize everything I'm going to tell you in the next 30 minutes with this. Basically, you need to communicate with respect. You need to be kind. You need to be professional. That's really the beginning and the end of what I'm going to tell you in the next 30 minutes. The practice has really changed since I started in August of 2000. And how? Okay, email existed way back then, but it was not how lawyers communicated. And I actually liked how lawyers communicated before for several reasons, but it was by snail mail, believe it or not. If you have a case against each other, you would dictate a letter, you would send that letter outlining your position to the other side, you get it in the mail the next day or a day after that. And it was always a big deal about 9 or 9:30 in the morning when the post office would deliver the mail and you see what you're going to work on for that particular day. What was the benefit of doing that? Believe it or not, the benefit. It was time to think. You had the ability to take that day to look at what your opposing counsel was doing and really give a measured response. Today with email, there's a lot of pressure on lawyers, which you've probably felt for your entire professional life, that you need to respond quickly. It's pressure from judges. Are you going to get back to us now? And I bring that up just to not tell you about the difference, but I think it's important that you have to take great care to look at the messages that you are sending. If you're firing something off right away, that you get. I was taught this right when I started practicing in August of 2000 by one of my mentors. It's called the 24-hour rule, which I will tell you about. You get a message from opposing counsel or somebody that you don't like and you get fired up and you want to hit back and you want to do it right away. It's a natural instinct if you're a litigator, if you're a business lawyer too. And my practice, if I get one of those messages, is that it's almost therapeutic. I will dictate my response or type out my response and say everything that I want to say because I'm upset, but I don't send it right away. I set it on my desk and it sits there. And I come back the next morning and I read it and I think, is this really how I want to respond to this letter that I don't like? And about 75% of the time, I'll say, no, I don't want to say that, and I will change it. I would encourage you to do that and just to think before you talk. When you get the pressures of instant responses from either the court or counsel, try to be measured, and especially in those times when you're upset, take an extra day before you respond. I think it will do well by you. Basic things that I think we need to think about. People say things on social media that they would never say if you are face to face with somebody. You wouldn't dream of doing that, and unfortunately, we see that every day. That can bleed into, in my opinion, conversations that we have on email, where you're not thinking about how this looks when you get it, when you fire off a quick response. A couple of things I do practically, I try to have professional discourse in my email. I use introductory phrases like good afternoon or good morning, whoever, dear whoever. I always start it, thank you for your email message. And I end it with a salutation as well. Why do I do that? I think a lot of times the tone in our email discussions really might not say even how you're feeling, but it looks that way upon further reflection. And I just do these things to modify how I talk, just to make sure it's clear that I'm trying to be professional. I've got a couple of rules that I keep in mind with every email that I type. The first one is, when I type it, I'm assuming that this will be an exhibit that's going to be in court someday. I'm going to end up in Judge Schreier's courtroom or Judge Hoffman's courtroom, and exhibit A is going to be this letter from Schulte to whoever. And wow, I've got to own that letter. That's me speaking right there. Do I want to own it? Am I being more than a zealous advocate? Am I being a jerk? You need to be cognizant of that. So think about that. That leads me to my second point, which is part of that. I have what I call, would my mom like this? Would my mother like this? And I think that's a good way, quite frankly, to practice law for communication that's written. Would I be able to show this to my mother, and would she be proud of me or think that I'm doing something that's appropriate, or would she be disappointed in me? Certainly, we have to be zealous advocates for our clients. We have to do that, but it's just important to realize the tone that we have when we communicate with opposing counsel. One thing that I've learned over doing this for 20 some years too is the importance of a phone call. And I think that that is greatly diminished in how we communicate with each other. We don't talk on the phone anymore with each other. It's a lot easier just to send, to blast off an email and not have that human interaction with the lawyer on the other side. I was taught this by Mark Haig, my good friend and mentor when I started practicing law 20 some years ago. He encouraged me to just pick up the phone and call the lawyer on the other side. We should not rely entirely on email. Email can be a crutch, okay? It's easy, again, to type something on email and not make that phone call. But what that can lead to in your practice is misunderstandings, miscommunication. If you got an issue on scheduling, whatever it is, a lot of times you just call the lawyer on the other side and say, hey, do you really mean this? What's the deal with this? And you can work it out in a phone call. So I would encourage you to pick up the phone, be willing to do that, to talk to the lawyer on the other side. It will be good for your clients. It will be good for your practice. Now, certainly that's encouraged, but does that mean that you eliminate confirming phone calls with lawyers on the other side? No, you've got to have confirming written correspondence frequently, and a couple of things to talk about with that. On the litigation side, you will live and die by extensions of time that are given to you by your opposing counsel. I remember being in law school thinking, God, I can't wait till day 31. I'm going to serve this request for admission, and they're not going to answer, and I win the case. Thank you, Roger Barron, for teaching that to me at U.S. State's Law School. Okay. Well, it really doesn't work that way. And what you will find as a litigator is that you're going to need extensions in order to survive in the practice of time. Okay. So that happens frequently in the practice in South Dakota. A lot of times you'll have cases against your friends, and that's great. There's nothing wrong with that, but you can't abuse that. So a practice tip that I would tell all of you is when you get an extension time, the other side agrees, just put it in writing, because you can't abuse that, okay? Because your opponent is zealously representing their client too. And it's just good practice that you put that in writing. I had to do that with a friend of mine this week. We've got a fairly contentious wrongful death case. We're going back and forth. I said, I need more time. He's like, it's no problem, put it in writing. He's got to explain that to his clients too, okay? So it's incumbent on you to get the work done. Just eliminate those awkward conversations. When 30 more days go by, you don't have that email in the file. They remember it one way, you remember it another way. Put it down, okay? Put it in writing. It's also important to put it in writing when you make settlement offers on cases. I negotiate by phone a lot. I think it's healthy in civil litigation to negotiate by phone. You talk to your opposing counsel about the strengths or weaknesses of your case, and you have a candid discussion, and you make an offer. Put it in writing, what the dollar amount is and what you're doing. It's the same reason that I told you before. You don't want to have that awkward situation that happens later. Well, you offered this, and now you're saying you're not offering this. Critical to do that. It's the same way too with respect to complex negotiations, where it's not just a dollar amount that you're offering. You need to be crystal clear in what you're offering and put it in writing. We'll talk about client communications in a little bit, but a lot of times you run that by your client before you do it too, so they're on the same page with you. But it's important, really important to do that in writing when talking with opposing counsel. So to summarize the important discussions we have with opposing counsel, just be professional. You're going to be tempted to not be professional on occasions in the practice because this work is hard, but be professional and respectful, and it'll take you a long way. Yes, yeah.
When you have those like settlement conversations, for example, over phone and
Sure.
follow up by email,
Right.
how specific do you try to be? Try to say, hey, we discussed this, this, and this, and the offer was this, or you just say, hey, consistent with our conversation from yesterday, you know, my client's willing to offer X.
Yeah, I say consistent with our conversation, client will offer X, but that's a good point. Now, on the defense side or the plaintiff side, it's probably important too that you call it a Rule 408 conversation or communication, okay? I do that as good practice too. Rule 408, there's a companion South Dakota statute, is the rule of evidence on settlement discussions. I've never had a lawyer in 22 years do this, but I like to make it clear it's not an admission of liability on the part of my client because I'm making an offer. It's a Rule 408 communication, and I say this is not admissible in any future trial that we're going to have in this matter. So why do you do that? If somebody would argue it's not a 408 communication, it is an admission of liability. You have in writing, no, that's not true. This is a settlement offer. It's under Rule 408. It's protected from use in any case. So that's the formality that I use with that. So, and I do say it's confirming our conversation. It allows them, when they think it's different, they can respond. So it's just good practice to put that right. Okay. And you know, this goes towards the third part, but extensions and calendaring. You probably all learned the value of your calendar. You live and die by your calendar. So just make sure that you calendar the extension. And I do it two ways just to make sure I don't mess up. I've got an electronic calendar that my assistant monitors, and I have a written calendar, probably because I'm an old dinosaur, but I have it in writing too, and I got that written from me all the time. Client communications. How do you speak to clients? Be respectful. A couple of things to consider. in our business, quite frequently, you will see clients when they are at their worst. They are in their darkest hour. And you might not see the best of them when they come in. And quite honestly, a lot of fire might be thrown at you about how the world is bringing this problem to their doorstep. And you need to know that, okay? It's part of what makes this such a privilege to be a lawyer, right? Because you get to advocate for people that are in their darkest hour. I would tell you to try to, you've got to be a good listener. You have to develop empathy and listen to your clients. I've had a lot of clients that have done things that they shouldn't have done over the years. I've had clients in criminal cases that have done things they shouldn't have done. A lot of times, though, they just want somebody to listen to how they got in this situation. And you should take the time to do that when you visit with clients. Take the time to do that, okay? Having said that, though, there's something that I want to let all of you know that I think is critically important for whatever your practice area is. Sometimes you have to say no to your clients. You have to say no. This might be obvious, but you've got a person with a problem. That's why they're in your office. And it is our natural human instinct that we all have as lawyers that we want to fix this situation. We want to help in this situation. And you're going to feel this pull inside of you that you have to say yes to whatever they want you to do, okay? Your job is to be objective and measured when you give this advice. And there are times where you simply have to say no to the client. This isn't a game. You're not a toy. You can only act within what the law allows you to do. And the worst thing that you can do in that initial client meeting that you have is to overpromise a result to this client. Don't do that. Resist the urge to do that. Temper expectations right from the get-go. So you've got to walk this line of empathy, of listening, understanding their problem, but don't overpromise what you can or you can't do. Sometimes you get the vibe in cases where, and I see this in criminal appointments or criminal cases, you say yes, and by the time it gets, over to here, it gets to be no for what the person hears, okay? Or you say no when they think that it's yes. People want to hear what they want to hear when they're in difficult situations. That's what we deal with in this job. But what you need to do, though, is be strong enough to say no to the client, okay? You will have to confirm in writing the important and crucial client conversations. What are those conversations about? Frequently, and what I do, it's on authority that's given to you to settle a case, an offer that you can make, and you listen to the client. I confirm that in writing with them. Thank you for visiting with me today. You've given me the authority to do A, B, and C. I am going to proceed accordingly. That's just good practice. It's just good practice, because what happens at the end of the day when they say that you didn't do what I told you to do? You got that piece of paper, that polite professional email or letter that you sent where you confirmed that you had the authority to do that, okay? Do you have to confirm every single conversation that you ever have with your client in writing? I don't think that you have to do that. I, though, have a practice of doing memos to my files confirming communication that I do with lawyers. Do you guys do that? You have practice with that, so you're nodding your head. But that's a good way to go about it, too. And it's not something that you send to the client, but you do that. One, when you get to be 49 like me, your memory might not be as sharp as it was, and you want to put down the details immediately when you're done of what was just discussed. But number two, it protects you too. So if you've had an important conversation with a client or a witness for that matter, I will then type up a memo that I put in the file just confirming everything that was just done. And that's good, good practice for you to do. It's important to tell the truth with your clients. Don't Don't oversell it. I would also tell you too, as an extension of saying no to clients if you don't think you can undertake a certain course of action. You should not feel compelled to take every case that comes in the door too, okay? Lawyers, natural human instinct. We want to change the world and take on this case and fix this problem, okay? There's only so much that you can do. You can't fix every problem in the world, no matter that you might want to. You might want to. You have to have the discipline sometimes to just say no, for whatever the reason might be. Might be that you're too busy right now, you have too many cases. It might be that you just have a bad feeling with this client that's going to go off the rails. You can just feel it, whatever it is. It's okay to say no and not take on every case that comes into your door, okay? Crucial communications with clients. There's something that I think we all need to know to and to consider, and that's timeliness. Rule 1.4, the rules of professional conduct, is the rule that you need to look at and examine. It talks about our duties as lawyers to be prompt, is the language that's used, to be timely in keeping our clients informed or advised as to what's going on with the case. And look, I'm not naive. I have a large number of files. I have my phone ringing every day. This is the hard work of a lawyer. This is the hard work, because what you're feeling in your mind is, I don't want to talk on the phone all day. I actually want to like work on your case. I don't want to talk on the phone all day. Okay. That's a natural human feeling. But I'm telling you right now, you have to, under the rules, keep your client advised as to what is going on. You have to do that. I'm currently sitting on the disciplinary board now for a term. And just as a general proposition, we see those types of complaints that could be remediated with a quick phone call or an email, where clients are just complaining. I have not heard from my lawyer in 5 months or 8 months, whatever it is. And I say this to you, again, not being naive, because when you are practicing, there are pressures, and it's hard to do, but you have to keep up. The rules require you to communicate with your clients so they can know what's going on, not only with the big decisions, of course, but just what's going on with the case. And you have to do that. Okay. Another crucial communication with the client would be on fees. And let's talk a couple of pitfalls about that. You've got to be very blunt with the client right from the get-go, what you're going to charge for your work. You really owe it to them to let them know what you're going to charge on an hourly basis. I tell them, although it's extremely hard to do, I try to give them an estimate what it's going to cost for the duration of the case. This case could last a year, could last 18 months. It's going to be expensive. The rules of professional responsibility strongly suggest that you should have a fee agreement that's written in every case. Certainly you have to with a contingency agreement on a personal injury case, if that's what the client wants to do. But be upfront with the client on fees right away. The trap you can get into is, oh, this is going to be no problem. Don't worry about fees. I'm going to get this wrapped up for you in 2 weeks. Don't worry about it. Well, it doesn't work that way. And then you're stuck, and you maybe have had a slip of the tongue. I'll do it for free. Don't worry about it. I'm going to charge you $100. It's never reduced to writing. Well, then it's awkward, right? Then it's awkward. So again, you have this pull that you want to help and do things for people. That's why we're lawyers. But it's just good practice for communication with clients that you get fees set up right away, and that you do it in writing. One other bit that I learned from Tom Frankman at my office when I was a young lawyer on communication is the hard phone calls. And you're all going to have it when you practice law. When I get to work every day, I do a list. It's the first thing I do when I sit down. I get my cup of coffee, I turn on my NPR. These are all the things that I need to accomplish in my day. And I'll put down 20 things and maybe I get 3 of them done. I don't know. It's the way it goes. But you will all encounter the hard phone call that you have to make because it's a client that you frankly don't like, because it's hard news that you have to deliver to a client, whatever the reason is. And Franklin told me when I started practicing, those are the first phone calls that you make during the day. You make that right away, even though they're hard. Because what that leads to, if you don't do it right away, is procrastination. Then you think, well, I'll do it at 1:30 today. 1:30 ends up being 5. Well, I can do it tomorrow. I can do it the day after that. Then it leads to a term that the D board knows called head and sand disease, which is something that can happen because our work is hard, okay? Our work is hard. And I'm just telling you, it's good practice to make those hard phone calls when you get to work and do it first thing in the morning so it's out of the way. You will feel better. You're serving your client. But we're not always the bearers of good news, right? I mean, this is the only profession, if you're in litigation, where you're on one side and the person on the other side's goal is to thwart everything that you're doing on this side. It's not your typical job. So there are pressures to it. But give them the honest truth and do it right away. That's the way that I've done it for 20 years. And I would suggest that you do the same. Do the hard phone calls right away. Another one on billing, I would suggest to you a critical client communication. Bill monthly. Don't let your bill get to be too high. Let the client know where you're at. Bill it monthly. Coworkers, a few things to consider with communication with coworkers. Last category. Deadlines are important in what we do in law. So communications with coworkers. You're working with a partner. They want something from you, a research project, whatever it is. Just be really clear on the front end when they want that done, okay? I'm guilty of this too when I get too busy and I'm not clear in the advice I give. But just have a deadline when they want it done. That's going to help you. Put it on your calendar so you can manage your calendar. All right. So do that. Number 2, this is something that I learned early on too. There's no such thing in the practice of law as a stupid question. Okay. The work that we do is hard. It's very hard. And you should never feel inhibited as a young lawyer when you don't know the answer to something or you've been tasked to do something and you're not quite sure what to do it. You should never feel that, hey, I can't walk into that partner's office and ask them this question. You should never feel that, okay? If you have a question, ask it. That's a critical communication with your coworkers. Don't hesitate to do that. Get time to do it. It's much better to do that than to bury it and move forward where you secretly know you don't really know what you're doing and you just don't want to embarrass yourself with a question. When I was a young lawyer, I wore out the path between my office and Mark Haig's office or Ed Evans' office every day. Every day I lived in their office. I don't know what to do on this, okay? And it's not only your law partners. Rely on your classmates too. Rely on the people that you went to law school. I spent 30 minutes this week with one of my very good friends from the class of 1999, and we were discussing a difficult situation. We took a half hour just talking through it, the ins and the outs. So you can rely on people too in the right situation that aren't your law partners. So my advice is just be open and honest with where you're at. There's no such thing as a stupid question. You have to ask that question if you don't know. And the reason why is the work that we do is hard. It's hard work, okay? So don't feel at all hesitant to do that. Inter-office communications. Who's the most important coworker that you're probably going to have during your career? I have an opinion on that based on experience. I mean, who do you think? Who's the most important coworker you're going to have? Yes. Tam said paralegals. Your assistant and your paralegal can make you or break you, okay? You need to have a good relationship with them because you will be too busy to do everything. You need to treat them with respect, okay? I like having team meetings with my paralegal and my secretary. We go through the cases where we have this, this, and this. We sit down and we talk. I try to be extremely polite and professional to them because I know at the end of the day, they can make you or they can break you. And they will be critical to the success that you have in your legal career. All right. The same goes true with the filing clerks at the courthouse. They're critical people in your practice. You need to be on good terms with them. You have to be on good terms with them. Court reporters. Court reporters are very important in litigation because you're going to need a transcript by a certain time, and you're much more apt to get the work done for the person that's nice to them than the person that's not nice to them. So this comes back to what I told you at the beginning, really to answer all these questions. Just be professional and treat people with respect. So deadlines, treat people with respect. Your secretary is the most important person in your practice. So I have, I think, about 10 minutes right now. I don't want you to think this sounds like doom or gloom or anything that you should be worried about in the practice. I'm just acknowledging it's hard. It's a great life. I wouldn't change anything for the last 22 years. It's been fantastic. And yeah, so any questions about anything at all? Yes, Brooke.
Okay, I'm putting you on the spot here, but if you encounter an uncomfortable situation with like a colleague, an opposing counsel, or even with your client, like I'll give you an example and ask how you would handle that. Sometimes as a female attorney, clients, opposing counsel, or just the general public think that I'm a legal assistant and not counsel. You know, if you're with a female colleague and a client or opposing counsel assumes that, how would you kind of rectify that?
I mean, I've had that happen.
Yeah.
You know, I had some farmers that I was representing that were older, and then I had an associate from our office there, and they said to me, well, can your secretary do this for us? You know, I just said, oh, she's not secretary. She's a lawyer. She's working on this case, and you just need to address that right there. These are hurdles that the females face that are entirely not fair, but it happens. And I think it's incumbent on older lawyers like me to correct that immediately. You just have to do it. So I'd just be very blunt. I haven't countered that though. I haven't countered sexism in my 20-some years. We had an example, which I won't name names, but we had a case several years ago where client didn't want a female lawyer in the case. And we just said it's not acceptable.
So how do you deal with that though? Let's say it's not an internal thing where you could, set your clients straight. You're, 7 lawyers on a case, and you see a lawyer that, making comments that you think are unbecoming.
Right.
Co-counsel who may be younger or maybe female.
Like on the record or even off the record.
Yeah, I mean, emails, whatever. I mean, how do you address that? Because obviously you want to be collegial with, your colleagues.
Right.
But sometimes you can't let that stuff stand, because if you do, that becomes a big issue.
My opinion, okay, we're all officers of the court. Everybody that's in this room, we're all officers of the court. And we shouldn't stand for that. It's not important. It's not important. So you should tell them it's not. That's right.
And how do you do that? They have significant.
I call them on the phone and say, you can't do that. Have I had to do that? No. So, but that's, just say you can't. Yes.
Pivoting a little bit.
Yeah.
You talked about having to stay in contact with your client and keeping them advised of the case. Can you speak to the opposite? Like your client won't stay in contact with you?
Yeah.
How do you?
Yeah, good question. Yeah, and you're gonna go through that as lawyers, right? It's going to happen. The flip side happens. You gotta pay for your file. You gotta pay for your file, either through an email, keep a hard copy of that red letter, send it by snail mail. You know, I try to get in touch with you with this offer or this. You have to pay for your file to cover for yourself. And what's the end result of that? Okay. If it gets too bad, and it's got to take some time to get there. So this isn't, don't take this as an automatic thing, but if it gets too bad, you may ultimately have to move to withdraw. I'm not saying you can move to withdraw just with an uncommunicative client. You can't do that. But in the extreme situation, you're going to have to move to withdraw. I had a lawyer on the other side of a case with me who had to do that recently, where I had served discovery, and I think his client had disappeared for like 8 or 9 months, and he was left with the situation. Well, what do I do? You know, I can't do anything. So have to get the court's permission to withdraw. You can't just quit. And that's an important thing to know. You can't just quit. You've got to get the court's permission in a pending case. Quit. But that's the nuclear option. I mean, I had a case, oh boy, 15, 16 years ago, where I hired a private investigator to go find my client. And yeah, and he found my client. I advised my client I was extremely upset. He was not staying in touch with me. So I've had to do that too. So that's why I say it's a nuclear option.
Build a client for the private investigator.
Yeah, I did actually. Yeah. Yeah, I did. Well, we had a better understanding after that. So, you know, you don't have to go nuclear and quit right away, but you got to protect yourself. So pay for your file. I tried to call him. He did not call me back. Yeah.
So if you're in that situation, you know, obviously you could do a noisy withdrawal with the court, or sometimes you can try to do a quiet withdrawal.
Right.
You have advice, maybe you might need to explain what a noisy withdrawal is, but can you kind of walk us through how you decide which one you may do?
I try to do a quiet withdrawal because you don't, I mean, you still have duties or obligations to your client and you don't want to get your case. You don't have to. So I'll try to be real vague.
And what is a noisy withdrawal, just in case?
If they're telling you to do something, I don't know. I mean, I would be really reluctant to do a noisy withdrawal, but what that would mean to me is that you put all your cards on the table while you think you got to get out of the case, you know. I try really hard not to do that. Really hard not to do that. I had a client, quick war story. I had a client that did disappear from me, came back, hadn't seen it for a while. We had a trial coming up, and he came in to meet with me on the Friday before Monday trial. And he walked into our office, and he had a red mohawk that's like up to here, and we're going to trial on Monday. And this could be potentially bad because the jury pool, a lot of older people from rural parts, and we needed to be. And I didn't. You want to wear a red mohawk? That's fine. That's up to you. So that's just what happens when you lose touch with it. We sat down, and I said, "You know about your hair?" He's like, "I knew you were going to tell me that it'll be gone by Monday." So, yeah. Yes.
About communications from prospective clients, they're sending you documents.
Yeah. Yeah. Right. If you don't take the case, or they just do it unsolicited.
Unsolicited.
Yeah. I mean, I'm just real clear in my communication with them. I mean, I've got an example this week. I told somebody I would take the case, I would take no action. Those are the two things you got to say, right? I will not take your case, and I will take no action. So there's no nuance there. And I've got a person still sending me stuff. You know? So I'm just responding and saying, thanks for sending this to me, but I'm not taking your case. And I will take no action. So. Does that answer your question?
Yeah.
You just have to be really clear what your intentions are. Anything, fire away. Not even on the topic. Anything. What do you got? Keep going.
So say you're representing a client for some time, and opposing client is kind of hopping around for attorneys.
Yeah.
And you've been very patient with
Yeah.
the guy on the other side,
Right.
and you want to be courteous to the lawyers on the other side. At what point do you say, well, we've been doing this for X amount of years.
Yeah.
The courtesies are starting to.
Yeah, you have to do that. I mean, you have to advocate for your client. The other side's got client control issues, and that's always, that's a red flag. Taking cases on when somebody wants you to be their lawyer and they've been through 3 lawyers. Wow, real red flag. Okay. But yeah, I mean, there's gonna come a time where you just can't do that. You gotta get your relief from the court, whatever it is, if it's a motion. So that can't go on forever. It can't go on forever. And that's like saying with extensions, you're gonna live and die by extensions, but it's important on you though, as a lawyer to not abuse that. We all gotta work together, even though we're against each other. Kirk, yes.
Yeah, thinking about corresponding with opposing counsel in the email age, and maybe the answer to this question just depends. Do you find it useful to type out a letter, print it to PDF, and send it by email, or is that just a waste of time?
Yeah, that's a great question. I've got some probably disagreements in my office, but if it's a more important issue, I'll do it on letterhead. It's probably generational. I still dictate. When I went to work, I was taught to dictate. And I might be the last, well, maybe Franklin was 72 years old. But am I like the last lawyer in land that dictates in our office?
You and Franklin, right, next to me.
Yeah, that's it. You can hear us. I like the formality of the letter. I like that, and then it would be attached.
Yeah.
I do that. I mean, I use email, but that's more important if I think it's going to be an exhibit for the court. And I just, I like that. Still use snail mail sometimes too. It depends on the situation. I really want to make sure somebody gets something on some email and snail mail. Anything.
How do you feel? So I guess in my experience, I've had a couple people call and it's like, I'm the 4th lawyer they've called. And they're like, I keep talking to these lawyers, but and here's my case. And they genuinely don't have an issue,
Right.
but no one's told them that
Yeah,
before. How
yeah.
do you manage
Tell 'em.
those expectations and tell them without?
You gotta be blunt and just
Yeah.
tell them. Because that's, people well-intentioned and being nice. Sometimes, look, I mean, a second opinion is good. I don't see it. Call somebody else, they might see it. That does happen, right? I just think it's important to be blunt with people if you don't think there's an issue. Right? Yeah, that's what I would do.
Can you speak on the importance of referrals, kind of just practice of law, and what's kind of your thoughts on when you refer a case, who maybe you refer them to?
Yeah, I mean, I do referrals. I read some people tell me that they're worried about referrals. I do it. I try to get the person to where I think they best suited. So, geographic, sometimes part of the state. I've been asked to be hired on West River cases, and sometimes I just think I'm not right, 5 to 6 hours away. So, I make it clear with them that I'm not taking on the case, and I will take no further action on it. I also tell them generally about statute of limitations, and you need to get advice immediately because your claim can be permanently barred if you don't. And I'll send you to the person that I think is best suited. One other resource I use too is the State Bar's referral service. They give them that number because there are lawyers that signed up with the state bar and pay a fee in certain areas. Anything, dumb die, anything. You didn't ask me. No. Is that it? Are we done?
Well, thank you so much, Eric.